Cortlandt Street versus Bonderman.
May it please the court, Mark Zauderer for the appellants. Respectfully, I would like to reserve 3 minutes for rebuttal.
Yep.
Thank you. We were here almost 8 years ago, and in the what I'll call the Cortlandt 1 opinion, this court set down the template for this case at the pleading stage. And I don't want to be presumptuous to tell the court what it said and read it to you, but I would say, because it sets the stage, I'd like to remind us what the court said was that it is sufficient at the pleading stage that the alleged facts and the inferences drawn from them establish the basic elements of the doctrine of piercing the corporate veil.
You emphasize the pleading stage.
Correct.
That case was at pleading pre-discovery, so it's
Correct.
not necessarily, the court's not bound on this stage.
Absolutely. I agree 100%. But we're at the summary judgment stage, and as we know, we have to show the facts back this up. But the legal template does not change, and we followed that roadmap. You know, before I came here, someone said, do you want to take the 18 volumes of the record here? I said, no. I would like to use my time to lay out for the court, and I think I can do it in 6 minutes. I can cut through 18 volumes and explain the fraud here. And not only the fraud, but to meet the standard that was established here, that in a piercing the corporate veil or alter ego case, we have to do two things. Otherwise, I would just be applauding with one hand. We have to show the complete domination and control of the judgment debtor here, which we did, and I'm going to get into that, married to the concept of a misuse of that control.
And so you say married, meaning they both have to go together.
Absolutely. And we took the template, and you know, in 5 or 6 years of discovery and 14 volumes, I'd like to say now what the two basic errors were of the appellate division. First of all, it rejected the group theory that this, as a matter of pleading, laid out. All you have to do is juxtapose what you said in Cortlandt 1 and what the appellate division said. They said, we don't accept the group plea. Can't explain that. I did watch the oral argument. I think I understand how they missed it, but they missed it, and that's in our briefs, and we discussed that.
Can I ask you what the collective entity is that you're proposing here? Is it just the TPG defendants or the TPG plus the Apex?
Right. The theory is TPG plus Apex. I'm going to describe it. I'll answer your question in full, but we're not going to focus on Apex because they were out on jurisdictional grounds.
Right, so if they're out,
Yes.
but your theory is the two together form a collective, then what does that do to your theory?
Because there was no finding on the merits that Apex and TPG did not engage improperly in this joint effort. There was just, it does not, the fact that they're out on jurisdiction, not subject matter, personal jurisdiction grounds, doesn't impact the analysis of what happened at the time when they acted together.
So you're suggesting that we would analyze the question of collective liability as against both acting jointly, even though one is no longer in the case?
Yes, even though there can't be liability on the other because there no personal.
Well, what's the collective conduct over
Okay.
here?
Okay. So,
What's the collective conduct?
yes, I'm going to explain
Yep.
the whole thing of him. I think the easiest way to explain this, I'm going to ask you to, if you would, picture in your mind's eye a horizontal line. Above the line, we have the 9 defendants here, all the TPG-created entities. Below the line, we have the Ellis, the Hellas entities. Right. And now I'm going to lay out the whole case for you. Okay. So above the line, the 9 entities, and I'm going to call them 1, 2, 3, 1 through 9. I can give you the names, but I want to take your time with it. So 1, 2, and 3 are the investment funds. These are the shareholders of the Hellas entities. Okay? 4, 5, 6, and 7 are the general partners of 1, 2, and 3. And 8 and 9, I'll come back to you when I explain to you the fraud here and how these were married together with their control. So here is what, this is record page 4374 to 75. After they acquired Hellas, they wrote to the SEC, and they explained how these entities were shell companies, which included the debtor and the guarantor. This is what they said on September 27, 2005. They said, this is the counsel, Cleary Gottlieb, writing to the SEC. The Luxembourg holding companies are merely, now those are referring to the Hellas companies, and they're holding companies because there's an operating company below, but these holding companies, the debtor and guarantor, had no operation at all. They were only created to funnel the money in, which I'm going to come to, and how they took the money out. They said, these are merely, and this is the lawyer for the whole complex here, they're merely intermediate shell companies that have no business activity or purpose beyond affecting the transactions described. That's this whole transaction we're talking about.
And so does that allow you to pierce the corporate veil?
It will, Your Honor, when I...
By itself?
Yes, because it happens because...
By itself? So anytime somebody represents the SEC, that in the course of a transaction, some company is a shell company for the purpose of holding something and has no business operations, its veil should be disregarded?
Not by itself. I would agree with you.
Okay.
They say
Would you agree that that's a common structure?
Absolutely, and I
Right.
think that's what frankly confused the appellate division. The appellate division saw this from the ground level. They didn't look at it from 1,000 feet, which is I'm going to describe, and that was the error here. And they go on to say, these entities, that is the shell companies, are controlled by the apex entities and the TPG entities and are not independent from these controlling entities. That's not independent. The second statement, they said, the TPG shareholders, that's respondents 1, 2, and 3, right above the line that I've hypothesized. They're not acting independently or directly in these transactions. They are private equity investment funds organized as limited partnerships with no officers or directors. They act through and are controlled by the TPG entities. That's 4, 5, and 6. Now, what I'm going to describe to you, which I'm sure the court wants to hear, is how is this structure used to commit a fraud? So at this point, I would say enter stage left, a Mr. Matthias. I'd spelled Calice, I'm told it's pronounced Caliche, and he had a counterpart on the Apex side. And by the way, these entities below the line I've created, these Apex and TPG, are joined at the hip like Siamese twins. And they each acted in relation to these entities as their counterpart did. So here's what happened. Calice was the so-called leader of the TPG deal team. He had a counterpart. He was the leader. He was responsible for overseeing these investment funds. He advised a review committee. He performed the business modeling. He liaised with the underwriting banks. He devised evaluations, and he was appointed now. This is where he goes below the line. He's appointed by the 3 investment funds, that's respondents 1, 2, and 3, to the boards below the line of Hellas. And this is where it's going to get interesting. So he becomes a board member in the Topco entity. He's a director and secretary of Hellas 1, director of Hellas 2. And he includes the issuer of the bonds, and manager and secretary of Hellas Finance. That's the guarantor of the bonds. And here's where it gets more interesting. He signed the documents relating to the CPECs that are going to be redeemed in a moment. I'm going to tell you how the fraud occurred. And he signed the PIC notes, the notes that are at issue here, and the indenture for those. And he signed the documents for the resolutions adopted by Hellas and then by the CPEC redemption agreements. So here's the way it worked. So the money comes in the bonds, and what does he do? He ships it back over the line to the various entities, and this is how they acted collectively. So,
Well, those entities held debt, no?
I'm sorry, who?
The entities above the, well, when the original purchase
Yeah.
of Hellas was done, various of these entities held obligations, right? Associated, that is, they financed it partly with debt.
Yeah, they financed it.
Right.
Exactly.
Right.
So the money goes through
And this
Hellas.
debt is held by some of these over-the-line companies,
Yeah,
whether
it all
they're...
goes up the line.
Right, yep.
This is what happened. And here's what happened. So Entity One, that's one of the three investment funds, it gets distributions. They divided up the money. That's why these were here, because they had different people behind them. 380.5 million and another 82 million to entity number one. 8.6 million to entity number two. 47.3 million and 6 million to entity number three. Entity four, which is the general partner of number one, gets $78.6 million. Entity six gets 11.1. Seven didn't get distributions. I'll come back to that. Seven was a general partner, but number eight was a consultant and received consulting fees, and nine provided advisory services to the funds, and that's at pages 73, 48 to 53.
But didn't the offering memorandum state that payouts were going to take place?
Yes, they were deceptive in two respects, the offering memorandum. First, it talked in the hundreds of pages, it says about money being used to repay deeply subordinated debt. That's the CPEX. Now, our expert opined, these represented your equity investments. That's not debt. That's misleading. They dispute that. You're going to hear that. But that's a factual issue for summary judgment in the experts. But here's where the real fraud came in. So the question is, how did they get their money out in relation to the CPEX they hold? Well, here's where they committed a fraud. These were valued, these instruments, at €1. In fact, just before this, they sold over $40 million at the value of €1. And later on, they did it again, which I'll come to. But for this, they unilaterally said, how do we value these to get the money out? And they valued them at €35 a piece with no support. They just made it up, totally. And I will tell you that the operative instrument, I'll find it here, says that, which they created, says that these have to be valued. If the value is going to be established other than what it is at €1, it has to be done at arm's length. That is in the document itself. I can give you the record site. And in the offering memorandum, while they may have said there's subordinated debt, they never said that they could do what they do here, which is unilaterally determine the value of what they're trading it in order to get their money out. And that is precisely what they did. And
Well, they based it on a valuation of 3.2, right?
they
3.2 billion euros?
whatever they valued it sufficient at a number that if you took the 3.5 times the valuation, or 3.5 euros times the number of CPEX and whatever else they're putting in, they were able to get all the money out. That's what.
You know, my question is a little different. So
I'm sorry.
This is all related to their attempt, there was a suggestion, I think, by their lawyers, that they get an outside valuation of the company, right? And that wasn't done.
It was not done.
And they made an internal one instead for something like 3.2 billion
Yeah.
euros. And then a year or so later, a completely unaffiliated third party came in and bought the company for more than that.
Incorrect.
Okay.
Incorrect. And they'll tell you that because the company that bought it
Yep.
did not acquire the debt. They paid it was 500 euros. They paid 500 euros for the assets. 500, not 3.2. That's a fiction. And you can ask them, I'm sure, if you will. Now, coming
Counsel,
back to
could
this.
I ask you to just step back for a minute? And here's what I'm struggling with.
Yeah.
I understand you to be arguing that Cortlandt 1 says that collective liability is possible. And I think you also cite Pasalacqua and maybe, what is it,
Yes.
Morris. But I'm not sure I see a lot of discussion of why collective liability is appropriate on the facts we have here. Can you tell us why it's a good idea?
Well, I'll give you.
Based on our case law
Sure.
and the purposes of a collective liability theory?
Well, let's say you had 10 people who were acting together, and they buy a company, and somebody's trying to hold them responsible as controlling the company. Each one would say, I only own 10% of this
Yeah,
company.
but what would the parameters of the collective liability theory be under your view? So, for example, 1%, would that be enough?
I think you have to here you have well over 80% between the two, okay? I don't know, would 1% be? I don't know, that would probably a novel question, but here's the, if I may, the theory. It's really not new, it's by analogy like a conspiracy, this is not a criminal civil.
When you say it's not new, I think you're pointing us to Cortlandt and Passalacqua. Are there other cases from this court that adopt that theory or apply it?
I rely on Cortlandt. There have been some subsequent cases which have used that theory.
And
Passalacqua
that
does.
simply, I think, says it's, well, I see your lights on, but it says that it's possible.
Yeah, I'm sorry, see what?
Those cases say it's possible, they don't
Yes.
require it. So what are the telltale signs that would invoke this collective liability that exists out there but may not be appropriate in every situation?
What would, if people get together with a common plan and act in some way or receive the benefit of it, they constitute what they call themselves here, a consortium or a group. And so what we're saying is that the people who join this group, you can't say we're acting as a consortium and then not accept the responsibility of being a consortium.
So that sounds a little bit like you're saying every time these entities are acting in concert, they're subject to collective piercing.
They are if they do what I just suggest to you, I just demonstrated, that each played a role in either participating as an investment entity, as a general partner, or receiving the benefits so they could pass them on. And that's exactly what happened
Don't you
here.
also have to show that they abuse the corporate form somehow?
Yes, they abused the, well, they
Just
have
by acting together?
They set up entities and created obligations. They issued bonds, but these were just shells.
Each one, I mean, what I think I hear you saying is essentially we should import the overt act concept.
Yes.
That's very broad.
But
So if I take one overt act,
No, not just one.
okay,
not-
so how
I'm
is
telling
it
you,
distinct from, you said you have to play a role, so what does that mean exactly?
I'm not suggesting, as you may be alluding to in a criminal case, perhaps one overt act by one conspirator binds everybody. We're
So
not-
everybody has to take one overt act?
I'm saying we have demonstrated, yes, I think
What
that's
would your
correct.
rule be?
What?
Well, if we did the alter ego in the collective sense, what would your rule be?
The rule would be that if you have what's demonstrated to be a common plan, and you use a shell entity, as here, a corporate entity or other kind of entity, to perpetrate a wrong, that the members of that group who play a role in it are liable, because otherwise nobody's liable, except, there'd be no liability for the actions of particular participants.
But you acknowledge you would have to identify that a wrong occurred
Yes.
by those actions?
We would, and we have, and to say,
And knowing that the
Yes.
participation is knowing in furtherance
Yes.
of that wrong.
yes, and we've demonstrated here.
Can't be, I'm in the dark. I happen to be a part of this company, but I'm in the dark that indeed.
No, I'm not suggesting
there's a
that
fraud
that
that's being committed.
Extended that for. There has to be an abuse, as here, which had an effect of leaving the debtor insolvent and causing injury. And that's what you said in court when laying out the theory in Cortlandt 1. Every element that was in Cortlandt 1, we've established, and I suggest to you, it's certainly not it's not a summary judgment case against us, and this should go to trial. There was enough evidence here to create triable issues on all of these things.
Thank you.
Thank you.
Good afternoon, Paul O'Connor from Loeb and Loeb, on behalf of the TPG respondents, the only respondents in the case at this point. What I'd like to do, actually, before I get into my argument, is address a couple of things that Mr. Zauderer said. First of all, he was correct. We were here in 2018, so it was a long time ago when we were here on the motion to dismiss, and I think that's important. It was a motion to dismiss decision. The court was very clear that what it was laying out was that the pleadings were adequate at that point in time. As a matter of fact, the opinion itself says point blank that it is adequate and they shouldn't require more at this pre-answer, pre-discovery stage. That's directly from the Cortlandt 1 opinion. And as Mr. Zaderer said, you know your work better than we do, but just on the record there, that's what was stated. There was a reference to the SEC statement. First of all, it was a statement to the SEC in 2005, not in connection with the 2006 transaction. It used the word control, but again, we cited a case for the proposition that using the word control to the SEC has explicitly been held by courts in the state not to be the same as control for purposes of alter ego. And the entities that were shell entities were not the Hellas entities, they were Troy entities. And again, they're not the same entities that are being talked about here. It wouldn't matter anyway whether you were describing them as non-operating entities. There are lots of non-operating entities out there that are not being pierced. There was a mention to Mr. Caliche, Matthias Caliche, who is a former partner of TPG. He was dismissed from this case because there was no alter ego evidence. It wasn't personal jurisdiction. There was no evidence that he had committed alter ego type liability actions. So the idea that what they're going to do is try to ride in on the back of Mr. Caliche, who's not even in this case, makes absolutely no sense. I'm going to get to the fact that there's no evidence as to any of these TPG respondents, but they've now made it even harder. They now are not talking about them by name. They were talking about them as the respondents generally. They never use their names. They never talk about what any entity did. They've now taken to calling them entity 1, 2, and 3, 4, 5, and 6, 7, 8, and 9. I really have absolutely no idea what those entities are. And then again, there was a discussion of each playing a role, which I will get into here. The fact of the matter is the evidence is crystal clear. None of them played any role whatsoever. There is no evidence in this record, and this record is voluminous. As was already referenced by Mr. Zaderer, it's 19 volumes. That was all in front of the appellate division. If it was in there, I'm sure they would have brought it to your attention.
Does it matter if the CPECs are debt or equity?
Pardon?
Does it matter if the CPECs are debt or equity?
It does not matter. CPECs are actually a hybrid entity. They are both debt and equity. They're actually Luxembourg securities, and they're treated under Luxembourg as one thing, and they're treated here in the U.S. as a different thing, and it doesn't matter. Almost everything that Mr. Zaderer talked about, the valuation of the CPECs, fraud, et cetera, has nothing to do with the alter ego matter you have in front of you. What you have in front of you is something that's very precise, which is that has alter ego been pled as against these 6 entities? As this court is well aware, when we were last here, this case was much bigger. There were many more defendants. There were many more parties. There's hardly anything left of it. They amended their complaint so there were 10 or 11.
To establish it as to each individual, or
Yes.
can they collectively act?
So I'll get to that. I don't think that they can collectively act. I think that this court's jurisprudence has made it very clear that what you need to do in alter ego is analyze 2 factors that you set forth in Morris, which I'll get to now into my argument.
You think no collective liability is possible or available at Cortlandt?
I don't think
What do you make of the statement in Cortlandt 1 then?
Well, I don't see a statement in Cortlandt 1 that talks about collective liability. I don't think Cortlandt 1 stands for collective liability. And I don't think Pasalacqua stands for it either, and I don't think the Perez case stands for it either. I don't think collective liability makes sense in the alter ego context. Again,
Can you explain why?
well, the reason it doesn't make any sense is because there are other ways to get there, easier ways to get there. If people are doing the things that they're complaining about, you could bring a conspiracy count. They never did. You could conspire to commit a fraud. This court has limited conspiracy to tort claims, but you could conspire to commit a fraud. They're asking you to change the law and to make it such that piercing the corporate veil of a corporation is something that is done, rarely. It is done, but it's not something that's done in a usual manner. There are lots of corporations out there. Their veils are not being pierced, and I don't think it makes sense to go ahead and take a very specific doctrine, and again, getting into Morris, which was referenced here, and we agree that that's the standard, you have to show 2 things. One is complete domination and control of the corporation. That's the Luxembourg judgment debtors here. In respect of the transaction attacked. Here, that's the 2006 recap. And you have to do both of these things. You have to show the use of such domination and control to commit a wrongdoing in respect of the transaction that's being attacked. That's what you need to show, and that's entity by entity. It has to be. You couldn't do that as a group. And again, there are ways
Do
to
you
get...
dispute that collectively they dominated?
Well, again, I don't think so, because what you would be doing at that point is there are a number of factors here. None of them are determinative, but there are a number of factors for each of these prongs. And what you'd be doing is saying that if one entity somehow or another did, office the same, had the same offices as somebody else was involved in the capitalization of the company, somebody else was involved in the books and records, and putting that all together, you're going to pierce all those veils. I don't think that's what your jurisprudence says. And against the Morris case, which was decided 30 years ago, and we're in full agreement that that's the controlling standard right now. You'd be making new law, I believe. Yeah, sorry.
Okay. The appellate division, I think, held, and I think it's fair to characterize it as alternative grounds, that there wasn't a showing of complete domination, even if you were to consider it. I read them as saying, even if you were to consider the liability as a collective whole. And so could the case be resolved on that ground alone without exploring the parameters of what collective liability might look like?
Yes, it could be. Yes, it could be.
And even if one were to say there's some collective liability, you do have to establish that they use the corporate form in some violative way, right?
Yes, yes.
And so if the second part's not established, it doesn't matter if they acted collectively in any event.
That's right. That's correct. That's correct. And again, as has been pointed out here, the First Department's decision on appeal here applied the Morris factors very clearly. And again, just to repeat on this collective liability point, I don't believe that's the jurisprudence of this court right now. You'd be making new law, and we personally don't believe that it makes sense to make that new law. And the reason
let me ask you, go ahead. Go ahead with the reason, then I'll ask you my question.
Sure. I was just going to say that we don't think it makes sense because, again, what you'd be doing is you'd be making much more difficult something that could be done through a conspiracy claim to commit a fraud, which is what they're essentially alleging occurred here.
Well, that's what I was going to ask you, is if you were, so we didn't, I think, set out what you would need to do to establish collective veil piercing, right? I mean, we said it's theoretically possible, right? It's a viable cause of action. We didn't say, here's what you have to prove. So were we to read into that essentially the requirements for conspiracy, what would be the difference?
Well, what the difference would be is that you wouldn't have to go through the factors that you set forth in Morris as to how to pierce the veil.
Well, I understand that, but if the trustee here could have held all these entities liable, and that's a big if, through a conspiracy theory, conspiracy to commit fraud, what's the difference if we import that test essentially into communal or veil piercing?
Well, again, I think for two things. First of all, if you look at the situation here, what the appellate division found is there's no evidence as to any of these respondents having done anything connected to anything.
Yeah, that's sort of a failure of proof, which yeah.
Right. But again, on the whole idea of collective liability and pushing them all together, again, you'd be now making the court go through two analyses when they could go through just one. If they had decided to do this and they didn't do this, they could have pled conspiracy to commit a fraud, and then they could have proceeded that way.
Counsel, I'm not sure I caught into this argument. Essentially what I hear you saying is they should have gotten or could have gotten a judgment against each of these entities instead of having a judgment against only one of the entities, but they didn't. And as the chief was just suggesting, what's to stop us legally from using the same analysis that you would do to establish liability at the collective level for some kind of fraudulent, scheme, and applying it post-judgment in a piercing context? Why is that not allowed?
Well, first of all, I'm not sure that they're really seeking a judgment against one entity at this point. They're seeking a judgment against a large number of different entities.
No, they're seeking to enforce a judgment against a large number of
entities.
different
That's correct.
entities. They have a judgment.
They have a judgment, and they're seeking to enforce that judgment against a
Because their
number
claim
of different
is
entities.
the judgment debtor has been emptied out by the co-conspirators.
Well, they are claiming that, but again, I think what's important for purposes of this appeal is that's not the relevant standard right now. What we're dealing with right now is whether or not the corporate form has been abused. We're dealing with whether or not domination and control, and whether that domination and control has been used to commit a wrongdoing. We're not dealing with whether or not, and the question here.
And why didn't that happen here?
Pardon?
Why didn't that happen here? Domination and control to commit a wrongdoing.
Well, because again, if you look at the evidence here as to the 9 TPG-related respondents that are left in the case, there's absolutely no evidence of them having any contact with any of the Hellas entities whatsoever, not one. And I'd point the court to two places here where, again, I think it's important to look at what they've cited.
Sorry, when you say any of the Hellas entities, you mean the issuer and the guarantor?
That's right, Hellas
Okay.
One and Hellas Finance.
Yep.
I'd draw the court's attention to page 13 of their opening brief, footnote 21, where they say that all non-respondents operated as part of a deal team led by TPG partner Khalees. They've then got a footnote coming off of that, footnote 21. And if you look at that footnote, you'll see that there are a lot of record sites. It's a lot of work to go through them. But if you do go through them, you'll see that absolutely none of them mention any of the respondents. All they talk about is Mr. Caliche working as a director for one of the Hellas entities, which he was, and signing corporate resolutions. That's not evidence of domination and control. That's not evidence of anything. And again, and
I assume they had other directors.
they had other, I believe there were at least 6, there might have been 8 directors. And again, at pages 32 to 35 of their opening brief, WTC goes through a long discussion of the 10 domination factors that are set forth in the Pasalacqua case. And again, if you look at that analysis, it is respondent-free. All that they talk about there, again, are just generally record sites, the things that Mr. Caliche did as a director. Then they talk about the fact that we acted as TPG and we acted as the consortium. And I'd like to get to this consortium point because, again, this term shows up in the OM. It's not our term. The record is very clear. The OM here, the offering memorandum, was drafted by the bankers, which is typical. Why they use the word consortium, I don't know. But I don't know what the word consortium needs. And again, they found it's an ever-changing battle here with the WTC side to understand exactly what their position is. But I think it's now been said quite clearly. They want this to be a collective liability theory in which defendants in a case are not just grouped together, but are grouped with non-defendants, non-parties. The consortium includes not just parties that were dismissed on jurisdictional grounds, but parties who never had anything to do with any lawsuit anywhere. And again, I don't want to bore the court with this, especially late in the afternoon, but this case has been tried twice already. It was tried in London and it was tried in Luxembourg. And both of those cases, this is a complicated transaction. It involves 2 tranches of notes, PIK notes and sub-notes. It involves trustees. It involves WTC as the indenture trustee. So there's always some reason why the prior trial doesn't end everything. But it's the same evidence. It's the same witnesses. It's the same deposition transcripts. It's the same documents that fill 19 volumes in this court. In Luxembourg, the claimants lost. And in Luxembourg, the court said that this transaction complied with Luxembourg law, that it was done in full transparency, and that there was no element.
Is that because of what the offering memorandum set forth?
It's both what the offering memorandum set forth and what the evidence showed. And again, the court had access. It's the exact same evidence. I can't argue that there's different tranches of notes. We'll get to res judicata and collateral estoppel one of these days, I believe, but it's taking a long time. And it's because we've got so many different jurisdictions and so many claims and so many parties. But the fact of the matter is that the last thing that the Luxembourg court said, there was no element of trickery, which is an odd word here in the U.S., but I think it basically stands for fraud in Luxembourg, as translated. We then had a trial in the U.K. That trial was set for 6 weeks. The claimants abandoned that case 4 days into it after a couple of witnesses had gone. And again, they don't have dismissals with prejudice in the U.K., but they did drop the case, and the ultimate prejudice is you have to pay the other side's costs. And here they had to pay something called indemnity costs because of the unusual nature and the weakness of the claims. So again, we're not letting anybody off the hook here. The parties that were let out of this case for jurisdictional purposes face trial in the UK, face trial in Luxembourg. This has all been done. And again, there's absolutely no evidence, and you will not hear any evidence. I'll finish with, well, I guess I have some time left, but the number one thing that happened in the appellate division, I think really where you ended up with the decision is counsel for WTC was asked point blank, What did these folks do? What did the TPG respondents do? And why should they be treated differently than any of the Apex entities? And again, one of the Apex entities was let out of this case precisely because there was no evidence in the record. They had cited no evidence in the record, and there was no evidence in the record that they had any involvement in the transaction. They didn't have any involvement in the transaction. Neither did the respondents left in this case right now. The results shouldn't be different there. And again, they cannot answer the question of what these respondents did, because these respondents did absolutely nothing.
Would you argue whether you say collectively or individually, the answer is still the same?
The answer is still the same. And I think I was going to say, I think another reason not to really change the regime, I think, of alter ego on this case is, again, you need to, there has to be some, if you're going to change from what Morris said the standard is to some collective liability, it ought to be in a case where you're figuring out what that collective liability means. Here, there is no collective liability because they didn't do anything. There's nothing for you to write about as to what the standard would be.
So this is not
for
the
courts.
proper vehicle, even
not-
if we were inclined to change?
Even if you were inclined to do it, I don't think this is the right case to do it in. I think that this is a situation where each of these entities acted independently from each other and did not do any of the things that this court said in Morris you need to do in order to establish alter ego liability.
Can I ask you how much weight you put on the disclosures in the offering memorandum?
What's that?
The disclosures in the offering memorandum.
Sure. Well, I think the disclosures in the offering memorandum were crystal clear, and I think that's why we got the result we did in the UK, and in Luxembourg. But-
And specifically, do you mean the completely dependent language or something else?
Well, I mean, first of all, everything in it was disclosed. As was previously noted, how the money was going to be used was clearly disclosed in there. The fact that these were non-operating companies that might not be able to service the debt was clearly disclosed in there. There was no wrongdoing. But again, on the OM, again, I'm just trying to fight the battle I've got, which is these 6 respondents. There is no evidence that these 6 respondents had anything to do with that offering memorandum. That offering memorandum was clearly written by the banks who were putting together the transaction for the deal.
So
But
they're just carrying out their assigned roles in the transaction, is that?
bankers.
I'm sorry?
Bankers?
The sub-entities.
Well, the 6 entities that I'm representing here today, the respondents had absolutely nothing to do with that.
Well,
They had nothing to do with anything.
they-
There's no evidence they did anything.
They benefited from the transaction.
Well, sure, they received
Right,
money, and
yeah.
we've cited cases for the proposition that the receipt of money, and the trial judge agreed with us, although he agreed with us on nothing else, and the appellate division agreed with us as well, that the receipt of money has nothing to do with anything. It's not an alter ego factor at all.
But aren't they subsequently moving money after they receive the proceeds?
You mean the respondents?
Yeah, no, the defendants, your
Yeah.
parties.
Yes.
Aren't they moving money between themselves post, after it initially comes in? Because I feel like that's the essence of the claim, that there's a kind of a shell game happening with money. It's getting moved around.
Well, some of the respondents who received money, and again, I'm not sure what the 1 through 9 was, but some of the respondents received money. Some of those respondents were funds, and some of those funds had investors, LPs, and so the money came into the fund and was then sent out to the respondents. There's no allegation here of shuttling money back and forth between Hellas and
respondents.
these entities and the respondents. There's no allegations like that.
Okay.
That's one of the factors of domination and control, but there's not even allegations of that, much less proof of that.
No,
so.
I do think that would be a telltale sign of domination and control, if you were able to move money in between the various entities. But you're saying that didn't happen here.
That's not even alleged. I will say that the vast majority of alter ego cases, and I've read a lot of them, obviously here today and briefing all this over the years, most of them are cases where there's a single shareholder, and that shareholder basically has a company and essentially is siphoning money back and forth between it. That's usually the
That
case
sounds
of
right.
what turns out to be alter ego. Not something like this. This is why I just don't think that this is appropriate for a collective alter ego theory like.
So this
like
is
they're
just a
running.
case where there was an offering plan, it defined how the transaction was going to play out, and the transaction played out exactly according to the offering plan.
It played out exactly. There's no allegation that anything other than what's in the offering memorandum happened. Exactly what is set forth in there is what happened. And again, I think it's important to understand that this company was acquired, invested in 2005. It was the third worst performing telecom company in Greece. Its performance increased dramatically, and ultimately the banks came about a year later and suggested that you might want to try to sell this company. There was an auction to try to sell the company. There was, in fact, a bid for 3.2 billion euros from a company called Providence, which is a U.S. private equity firm specializing in telecoms. That's the valuation that was used. It's true that there was no independent valuation, but they used the valuation that they got from a bid they had just received a couple of weeks earlier. That's the basis of the valuation that was used. And again, the respondents had nothing to do with any of this. It was done by others, but in any event, that's the valuation that was used. That was deemed not enough money, that offer, so they used the 3.2 billion valuation in connection with the recap. And really, just around the time that the recap was being implemented, the company received another offer from Weather Investments in 2007 for 3.5 or 3.4 billion, which was 500 million euros in excess of the debt. And the company then operated for 3 years in the face of the global financial crisis and ultimately defaulted on the debt. And again, the respondents had nothing to do with that. You know, the world did that. The economy did that. So with that, the light's on, and if those are other questions, I'll sit down.
Thank you.
Thank you.
With respect, there's a lot of intellectual misdirection here, okay? First of all, let me say on the theory that the court's been asking about, I think it's easy to miss the forest for the trees. We're looking at the individual entities. Yes, they did pass money through. What I think is relevant and consistent with the theory that was approved by the court in Cortlandt 1 is you have these two private equity funds setting up all these entities to do this job. As I say, the TPG entities above the line and the Hellas entities below the line, and they use these entities to distribute the money in what was a fraud here, and I'm going to come to that in a moment. And nowhere in the offering memorandum did it say that we could violate the provision, which is basically determine our own price. The idea of arm's length, look, if I'm saying I'm doing something at arm's length, it's not at the...
I didn't get a chance to ask your adversary about the valuation, how that could play in, or give him an opportunity to explain why it doesn't. But the part about distributing the proceeds to the various entities, he is essentially correct, though, that was decided previously in the offering. That played out as it was promised to play out.
With the idea that they were going to do this transaction and then commit a fraud, which they did. They set up these entities for the purpose of moving the money, distributing the money to those who had invested in this, and then yielding the 35 times the value. You can't do that. If they didn't do it at arm's length.
The offering statement says that the whole recap is something like 1.5, 1.6 billion, right? And it says that something like in excess of 900 million is going to go to pay the CPACs.
But they don't...
And the prior PIC loans.
They don't disclose that they had to change in violation of the CPEX agreement, the value. This says as follows: the redemption price shall be determined by the Board of Managers on the basis of the equity value of the company and its subsidiaries on an arm's length basis. They didn't do that. They didn't disclose that they weren't doing that. And the offering memorandum said...
You don't think that the Providence offer is an arm's length basis?
That was a preliminary offer, no due diligence. It was, but even if, let's assume it was, no, it cannot be an arm's length. An arm's length basis is not what some offer may be. An arm's length basis would be having an independent body, which was offered here, the accounting firm offered to do it, to evaluate its value. They didn't do that. By definition, arm's length is something independent, not something you decide can be a basis for you to value these CPACs at 35 times their value. I want to just, if I may, hit some of the other misdirection here. Mm-hmm. They talked about the Luxembourg proceedings. What they don't disclose that was brought by liquidators of Hellas 2, and they said in their opinion they did not represent creditors, that's the bondholders, and any arguments concerning a violation of creditors' rights were deemed inadmissible. The court said that. You didn't hear that from my colleague over here. And the issue was about what Hellas 2 knew vis-a-vis other Hellas entities in their directors and officers, not the misrepresentations or wrongdoings to note holders. And the London proceeding, there's nothing in the record they're pointed to as to why. I know because I was in London. This had to do with finances. But they do not argue in the brief either the Luxembourg proceeding or the London proceeding is res judicata. Kind of talked around. They said, maybe we'll get to res judicata someday. So, some misdirection there. And again, I just want to close with the observation that there are factual issues here for which the trial court, which spent, by the way, 8 hours of oral argument, it had and made very specific findings of the fact that go to control. And I think one has to look at this idea of control by a group as looking at this from 1,000 feet. It was set up by these funds to accomplish a person. Mr. Khaleesi said in a memo that we cite that if we can't sell this company, we're going to get several times what we put in. That's what this whole transaction was about. They set up the entities. They used them. I could go, I don't have the time. They know which ones they are. They're all in I made this cheat sheet from page 5444. I didn't want to take the time reading the entities, but that's not a fair shot. But so with respect, I say that the decision of the appellate division be reversed, and this matter should be remanded for trial.
Thank you.
Thank you.